Hello, this is Darrell Castle with today's podcast. Today is Friday, April 12th, 2013, and today we are talking about the Supremacy Clause. We are talking about nullification in the U.S. Constitution and the state's desire, the state's efforts to nullify certain federal laws saying they are unconstitutional. Is that legitimate? Can it be done? Or does the so-called Supremacy Clause supersede that and render their efforts to nullify null and void? Which one is nullified, I guess we could say? Well, the Supremacy Clause in the Constitution, at least that's how people who are opposed to nullification refer to it, is found in Article 6, Paragraph 2, and it reads as follows: "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." So when a state tries to nullify a federal law, as we talked about last Wednesday, the opponents of nullification say that it is irrelevant because of the Supremacy Clause. Their efforts, their lawsuits against the federal government, their efforts to nullify are irrelevant because of the, quote, Supremacy Clause. They say, the language is clear, they say, the opponents that is, that federal law is supreme over state law. It really doesn't matter what a state legislature says on this. Now, Barack Obama has signed the health care law, the so-called Obamacare. More than a dozen states have filed suit against it. About 24 states say they are not going to enforce it, at least not all of it. There are many other things across the state where many other laws, many other federal laws that the states are trying to declare null and void. Such things as the National Defense Authorization Act, which says that American citizens can be arrested, imprisoned without trial or without even charges. Many states don't like that, and they say it's unconstitutional. And of course it is. And they say they are not going to enforce it. But these so-called experts that the federal government trots out from some law school or another always say, well, that's your efforts are irrelevant because of the Supremacy Clause. But is that really true? Let's take another look at the Supremacy Clause and see what it says. Herein lies the entire essence of this argument. The clause says, "This Constitution and the laws of the United States," now listen to this next part because this is the best, "which shall be made in pursuance thereof." This Constitution and the laws which shall be made in pursuance thereof. In other words, it is the law of the land if it is made in pursuance of the Constitution. But that is an implication that if it's not made in pursuance to the Constitution, it is not the law of the land. And to say otherwise would be to say this Constitution and the laws of the United States and any other laws that Congress may think of any time now and forever are the law of the land. But no, it says the laws which shall be made in pursuance of the Constitution. And the states look at Article 1, Section 8, which sets out the enumerated powers of Congress, and they do not find health care. They do not find an enumerated power for Congress to legislate in health care, and thus they say this law is null and void. The Supremacy Clause allows the federal government to be supreme only in areas when it is in compliance with the Constitution. The federal government is supreme only in its enumerated powers, and it does not have a negative veto over state law outside the Constitution. This is, in essence, the whole argument of nullification. This was debated time and again across the spectrum in the Constitutional Convention. Many states debated this, and they insisted upon the Bill of Rights. They were afraid of the powers of the federal government. They were particularly afraid of the Supreme Court and the idea that the judiciary could get out of control and take away state sovereignty, and so they insisted upon a Bill of Rights, the 10 Bill of Rights. Of course, the 10th Bill of Rights being the one that says that power is reserved, unless it's enumerated, it's reserved to the states or to the people. This is the amendment that people seek to be enforced. The power is not delegated to the United States by the Constitution nor prohibited by it to the states or reserved to the states respectively or to the people. That is the 10th Amendment. And it is the basis, the justification for nullification of unconstitutional federal laws. And the Supremacy Clause, the so-called Supremacy Clause, does not forego that. It does not erase that. When the state nullifies a federal law, it is simply proclaiming that the law in question is void and inoperative, non-effective within the boundaries of that state. We will see who prevails on this. Is the federal government willing to fight another civil war? Are the states willing to do so? I don't think so, folks. I don't think so. We'll see what happens. We'll see how far the states are willing to push it, and more importantly, we'll see how far the federal government is willing to push it. It seems to me, I've thought about this a lot, in my own state of Tennessee, the Tennessee legislature just passed a Balance of Powers committee, established that committee in the state legislature to study federal laws and to determine when they are outside the Constitution. I personally think it is something that is long since past due. It would take a state governor and a state legislature with a little bit of guts and determination. What is the federal government's best weapon to fight this? As always, it is money. It is our money. It is borrowed money. It is money printed by the Federal Reserve. But nevertheless, it is money. The federal government tells the states, if you do this, we will cut off your supply of money. New York City alone gets about 12% of its budget from the federal government. Now, I don't see New York City as a nullifier, but nevertheless, the states all receive federal money and they are desperate for it. And so if you have a governor with enough guts and the federal government says, we will cut off your money supply, he could just say, and I will cut off your money supply. I will sequester all of the federal income tax money paid by the citizens of this state and hold that money in a trust fund until you change your mind, whichever comes first. That is what a governor could do, and perhaps that is what a governor should do. Is it time for this? I think so. That's my opinion, folks. This Friday, April 12th, 2013. Until next time, folks, this is Darrell Castle. Thanks for listening.